followed by steps to be taken during the arbitration proceedings. Then I would discuss about the important case laws which can become a turning point during the proceedings and the hearing. And last but not the least, what should we do post arbitration? To begin with my content, first I would talk about an introduction to arbitration. As we all know, arbitration is an alternate dispute resolution mechanism. Recently, few days back, Chief Justice of India, N.V. Ramanna, in a conference in Dubai organized by Indian Council of Arbitration, has said that arbitration is the most important mechanism to resolve the dispute in the globalized world. And I too also agree that arbitration in the present scenario is one of the best methods not only to reduce the caseload in the court of laws, but also very fast and efficient way to resolve the disputes. Coming to the benefits of arbitration, why the arbitration is so important. In the scenario of international arbitration, where important multinational companies are at stake and they fight between each other, but they do not want their issues to be disclosed and their issues to come to the knowledge of public platform, which can affect their market capital and the clientele. So the arbitration is very important in keeping the confidentiality of the parties. None of the arbitration awards and the judgment goes outside in the public platform unless they are appealed in the court of law. Second is party autonomy. Party can choose their own judges, their own arbitrators. They can choose their own counsels. Third is no application of CPC and court procedures. In the arbitration, there is no strict follow and guidelines to be followed with respect to the court procedures, such as affidavit or per se civil procedure code is not strictly applicable. It is not applicable. Third is that we can choose the technical experts. Arbitration in the field of construction arbitration is very important because we can choose the arbitrators as engineers, architects, designers who are technically expert in their respective field. The counsels can also be technical experts. This facility is not available when we approach court of law because the judges, they are not engineers, so as the lawyers. In the field of arbitration, the parties have full liberty to choose their arbitrators as technical experts as well as the counsels. Freedom to defend own case. The party, they can choose to defend their own case. They can have their in-house counsels. They can themselves fight the arbitration case, which is not available in the court of law. Last but not the least, the awards are final and binding. There are very, very limited and narrow grounds as per Section 34 of Arbitration Conciliation Act, which provides you the ground to appeal and to put the prayer to set aside the arbitration award. So in the present scenario, the arbitration awards are almost final and binding. The substantive and procedural laws which govern the arbitration is very important to discuss. In Indian scenario, generally the arbitration is between the two parties who have entered into a contract. So these are the matters pertaining to the Contract Act. So Indian Contract Act 1872 is the basically soul of the entire arbitration procedures. So this is the substantive law. Now the procedural law in India is Indian Arbitration and Conciliation Act 1996. Earlier it was 1940 and now it is 1996. So procedural law tells you that what is the procedure to be followed, how the arbitrator has to be appointed, what to do, what not to do, all these steps and the guidelines. However, substantive law, it talks about the overall philosophy of the contract between the two parties which they have entered into. Now coming to the arbitration agreement in our contract agreements. So the arbitration agreement in our contract agreements is actually governed by Condition 70 of 2249. Condition 70 of 2249 talks about that the sole arbitrator appointed has to be an engineer. If the appointed arbitrator is not an engineer, then it becomes a ground for appeal. Second is about the admissibility of the claim. Condition 70 says that all the disputes between the parties for which the decision of CWE or any other person in contract is expressed to be final and binding shall not form the part of claim. So these two statements, one about the appointment of engineer as an arbitrator, and second, the admissibility of the claim on which the final decision of CWE or any other officer such as accepting officer is final and binding, shall not form the part of claim. The last part of the arbitration in the globalized world is that India is party to the New York Convention 1958. This New York Convention is important because in the globalized world, all the countries have ratified this convention, which means that any arbitral award published in any part of the world will become enforceable in India if the location where it is published and India, both of them are part to the New York Convention. It helps in ease of business and also helps in establishing a country in the globalized world. The first point is with respect to appointment of an arbitrator. Section 10 of Indian Arbitration and Conciliation Act 1996 talks about the appointment of arbitrator by parties and courts. Schedule 4 talks about the fees payable to the arbitrator, and Schedule 5, which is the most important and sometimes become contentious, is the disclosure of relation of an arbitrator to the parties. The Schedule 5 is important because sometimes if the arbitrator fails to disclose the relation between the parties, if he has any, then it becomes the ground for the removal of the arbitrator and the award can be set aside. The second part is about the duration of proceedings. Unlike the Arbitration Act 1940, 1996 in the recent amendments have put Section 29A. The Section 29A limits the time for the hearing and the award to be published. The total time which has been given as per Section 29A is 12 months from the date of reference, and this 12 months can be extended by 6 months by the mutual agreement of the parties. Coming to the third part and the important part is the interim measures by court. Interim measures of court is defined under Section 9 of Arbitration Act, and the interim measures means where a party has to seek immediate relief and where its interests are getting hurt, and if this immediate interim measure is not attained, then it can go to loss or even can become bankrupt. So during the proceedings, during the arbitration proceedings, or even at the time of publishing of award, the parties can approach court and seek for interim measures. Similarly, Arbitration and Conciliation Act 1996 has given powers to the arbitral tribunal also to provide interim measures. This interim measure is provided under Section 17 of the Act. Again, the ground is same, that if the party thinks that its interest is getting hurt and if it does not get the interim measure immediately, then it can lead to serious losses or even lead to bankruptcy. The Act has been very cautious, and it has said that any such interim measure passed by the arbitral tribunal will have same power as of the court of law under CPC, Civil Procedure Code. So any interim measure provided by tribunal under Section 17 is equally enforceable as any order given by court of law. Fifth point, and the very important point, is equal treatment of parties covered under Section 18. Section 18 says that arbitral tribunal should give equal treatment to both the parties, and the parties should have full opportunity to defend their cases. It is important because sometimes the party in front of Union of India argues that the methodology adopted by Union of India or some sections or some arguments are untenable and cannot be entertained, but this is wrong. Section 18 can be invoked in such cases or in such arguments, and Union of India should equally and with full force should defend their cases. Last but not the least is the competence of tribunal. Competence of tribunal is covered under Section 16. Now, what does it mean? Competence of tribunal is very important concept in the Arbitration Act in section 16, which says that the jurisdiction of the arbitral tribunal as well as the admissibility of the claim, if there is a dispute on these two issues, the tribunal itself has the power to decide whether it has the jurisdiction to decide certain matter or certain claim is admissible or not. The tribunal itself becomes the judge of its own dispute or contention of the subject matter. Why it is so? In order to reduce the litigations approaching the court and the matters are resolved at faster track. The contention under section 16 is that if the party has applied for any dispute with respect to the admissibility or the jurisdiction, and if the prayer gets rejected under section 16, then the remedy lies only and only under section 34. Section 34 is applicable after the award is published, and the prayer has to be put that arbitral award needs to be set aside. So this section 16 is very tricky. If the Union of India, whenever we are defending any case and we think that certain claim is non-admissible or the tribunal does not have jurisdiction to sit over certain matter, then it is better to use either section 17, which is interim relief by the tribunal, or section 9, interim relief by the courts. Because if we go through section 16 and the prayer is rejected, then the only remedy lies in section 34.